It's a great thrill to be in Leeds to give the second Hamlyn Lecture. Leeds has got a fantastic law school and has a centre for the study of legal professions, so I was particularly pleased that they agreed to host tonight's lecture. I also want to thank my colleagues on the Post Office project, Sally, Karen, Rebecca and Paul. We've been working together on the Post Office now for a good deal of time, and much of what I say tonight draws on work that we've all been doing together. And I'd like to thank the Hamlyn Trust, the trustees, for inviting me to give the lectures. It really is an enormous professional thrill and honour indeed to be asked to give these lectures on the subject of lawyers' ethics. Finally, I'd like to thank the sub-postmasters and the sub-postmistresses who have been through an enormous amount, still are many of them going through a tremendous ordeal. Thank you to them for sharing their experiences with us as researchers, and I dedicate these lectures to them. And thank you too for coming and listening. In the first lecture, I suggested that law had a problem with excessive zeal, aggressive self-serving interpretation of law and facts, coupled with traditional scripts like the claim we do law and not morality. True, but only half true, and they make extreme behaviours more likely still. A shallow, somewhat complacent idea of professionalism is accompanied by the psychological frailties of human decision-making. They undermine our objectivity as lawyers. Zeal and frailty take lawyers beyond sometimes honesty and legality through aggressive lawyering. Now, this lecture is about how such risks are magnified within organisations, how, especially with or for organisations, what lawyers do and how they are used can pollute rather than protect those organisations. Now, although potentially true of any client, I emphasise organisational clients because they have the added social and legal complexities of being artificial entities involving many people. At one level, my argument is very simple. It is a problem of the slanted signal. Putting court advocacy to one side, if, when advising, a lawyer can imply that X is legal or Y is true when it is probably not, then clients are going to take bad decisions. Bad as in wrong or risky, and bad as in lacking in integrity. They may also tend to communicate those decisions in misleading ways. Now, this problem is magnified because, of course, clients sometimes want a slanted signal. They want to hear good news, and lawyers, being human and wanting happy clients to pay their bills or salary, want to tell them what they want to hear. In an organisation, that distorted communication passes between actors and levels, each with their own agendas and audiences to please. The processes have some subtlety and can take on a life of their own. They stem from a desire for simplicity, simple signals, and what being commercial can mean when asked, is it legal? I assume the desire for simplicity is an inescapable fact of individual psychology and organisational culture. Why, in extremis, does this manifest as a lack of integrity? Is this just the system, or lawyers being lawyers? How much of it is misconduct? To consider these questions, we need to examine how organisations interact with lawyers and how individuals and systems create integrity gaps and mutual irresponsibilities, how practices that look normal have the capacity to be deeply harmful, and when and why they promote the client's interests over the interests of justice. I call these practices irresponsible orthodoxies. Irresponsible orthodoxies, as we will see, are built on routines, practical scripts, and when managed in bad faith, when lawyers forget integrity in the interest of justice, these routines create legality illusions, illusions that enable badly led organisations to say, we can do what we want. We can pretend we did the right thing, if not with impunity, with significant levels of deniability. Now, more later on what legality illusions are, but one example for now. 2 years after the Post Office were told their lead expert was tainted, Paula Venables wrote to a government minister in 2015 to say that they had found nothing to suggest that any of the prosecutions the Post Office had brought was unsafe. Nothing to suggest. Now, there was lots of evidence that some convictions were unsafe. You could argue, I suppose, that no one knew the convictions were unsafe, but saying there was nothing to suggest any conviction was unsafe was untrue. Whether she knew it or not, it was misleading. Was it the system and its routines or individuals at fault? Was it the system and its routines or individuals at fault here? Was it both? To understand how legality illusions build up, we need to understand what organisations want from lawyers and how lawyers respond to that desire. Now, I can only sketch out some assumptions here, but what organisations want, I would say no organisations are alike and no theory of them uncontested. For businesses, their primary goals can be simplified as providing financial reward, status, and I suppose sometimes meaning to those that work in them. They tend, of course, to be managed with a keen eye on profit and reputation. And these systems can become unbalanced, typically through profit maximisation. Now, profit, of course, is essential, not bad, but profit maximisation can be dangerous, driving excessive cost-cutting and other risk-taking. Financial and reputational drivers can cascade through the organisation and, when unbalanced, can diverge from the long-term interests of the organisation. Senior managers, particularly sensitive to reputation and financial signals, set priorities and take critical decisions. Typically, the lawyers work with them. Lawyers are supposed, of course, to act in the best interests of the organisation. They're the client, but usually they take their orders on what this means from the executives. In times of conflict, there can be huge difficulties in working out who the client really is or what is actually in the client's best interests. We also know lawyers sometimes keep trouble away from boards. They think, assume, or are told that the board is better off not knowing about dirty linen, for instance, the Prince Harry case against Mirror Group newspapers. Now, we might hope that what organisations want from lawyers is sound advice, accurate as to the law, and sensible as to their conduct. It's the reason why, after all, Baroness Hale identified legal professional privilege was given as a fundamental right. But what organisations actually want is simple signals in complex contexts. Even when acting in good faith, they want permission or validation. They want to be told you can do this, it's lawful, or we've investigated and you behave justly. And they want to be told this with confidence and simplicity. An example, let's take the invasion of Iraq and pretend I am Tony Blair. I got ChatGPT to do a cartoon of me looking like Tony Blair, and this is what it came up with. Now, if I'm behaving responsibly, I want to ensure the invasion is probably legal, and I want to be able to present the legality of invasion with firmness and resolution to other audiences. So I want the answer to be yes, it is legal, and I want the answer to be a clear yes, a confident yes. Without clarity and confidence, I'm in difficulty. I need to command and persuade others inside and outside the organisation, the army, the government, Parliament, even the nation. So there's a problem with managing, representing and acting on uncertainty here. The military and civil service must be told it's lawful. Equivocation does not help them. The system arguably needs and definitely prefers a positive, simple response. All this gives rise to a number of dilemmas for the lawyer. How sure do I need to be to say something really is lawful? How should I represent any uncertainty? How should I cope with the foreseeable risks that my advice will be abused or misrepresented? There are other problems. The factual basis of advice or the questions asked can be biased in favour of a particular outcome. Advice requests can be left late to maximise pressure on me as the advisor to say yes. Draft advice can be subject to lopsided scrutiny from one side of the battle. In the Iraq example, the Attorney General agreed to advise late. He took meetings from those in favour of invasion, and on the key factual question, did Iraq have weapons of mass destruction, he felt able to rely on the Prime Minister's view. And he then changed his advice to be more favourable to invasion. Many international lawyers said he got that wrong. I don't have an opinion. I'm not an international lawyer. Whether true or not, the process he adopted probably, I would say, undermined his independence. Let's move on to the next point, being commercial. There are lots of pressures, implicit and explicit, subtle and unsubtle, on lawyers to say yes to their clients, like the pressures on the Attorney General. Read any recruitment brochure, attend any in-house conference, read any client-facing article, and the demand for lawyers to be commercial or business partners is strong. Being commercial can just mean being practical, not academic. And who could resist that? What's wrong with it? And why work other than in partnership with your client? I mean, it's common sense, right? But that's not all that is meant. Being commercial is also an idea used to dilute legality. Being commercial means flex when presented with a legal obstacle. A lawyer should not say no, they should say how. They should find a way around the problem. In the Barclays case, which I'll come to, they tried to say no when asked to draft a loan in an increasingly questionable form as a consultancy agreement, but they ended up doing it. Being commercial can mean flexing advice or drafting to be helpful, or turning a somewhat blind eye, or even a very blind eye sometimes, to a manifest legal problem. In-house lawyers do this because of a tournament of influence. They demonstrate their loyalty and helpfulness by flexing in return for status and influence. They hope this earns them the right sometimes to say no if it's really needed when things are really bad. Similar may be true of private practitioners, I think, especially those with big clients and long-term relationships. Donald Longavort has researched how sociological, psychological and economic forces like these penetrate deep into the interactions with lawyers and clients, how culture, if you'll forgive the cliche, can eat independence for lunch. He suggests commercial cultures like and demand sometimes intensity, passion and commitment. Commercial cultures expect optimistic construal, putting the best gloss on situations, what Longavort labels corporate grease. Being positive, he says, facilitates motivation, cooperation, and trust. Now, there are problems with passion and optimism. They are associated with unrealistic situational construals, a fancy way of saying getting stuff wrong, being overconfident. So when Post Office instructed lawyers to talk about suppressing evidence or calling their opponents liars and thieves or strategizing wild litigation tactics, in a perverse way, they are showing their commitment to intensity, passion and alignment with the client. It's just unfortunate they're also evidencing, it would look like at least, a loss of professional detachment and propriety. Disdain for these thieves and liars is a significant matter psychologically. It's a form of moral disengagement. It can be seen in legal fields as varied as finance, Trevor Clark's work, conveyancing, Eleanor Rowan, criminal defence, Mike McConville, Jackie Hodgson, Dan Newman, and so on. It encourages significant ethical failures. Organisations also tend to promote risk takers. Risk gone wrong can be excused as bad luck, managed or concealed, and so on. But to succeed in financialized organizations, you have to try and win big. Rainmakers have the power. The Gerard Deckhertz case or the Nigerian arbitration cases seem to be examples where big bills or the anticipation of big bills drove extraordinary behavior. And post office work has boosted the careers and income streams of several lawyers and firms over many years. Longavort also suggested something about lawyers' decision-making styles. He says these fit this greasy model. He describes the decision style as intuition and feelings, driving decisions as much or more than deductive or inductive reasoning. The lawyer's mind, he says, is trying to work its way towards meeting what the client wants. Again, the post office may provide examples. Stephen Dilly was the solicitor running the case against Lee Castleton. He started out thinking Mr. Castleton's defence had merit and asked his client some awkward questions, but is given a pep talk by in-house lawyer Mandy Talbot about, in quotes, serious ramifications for the business of failure. His more independent-minded questions about Horizon then go unanswered. As we will see, barristers Simon Clarke and Brian Altman decided against exploring why key Fujitsu witness Gareth Jenkins gave tainted evidence. This came at a time, coincidentally or not, when Mr. Clarke had noticed the Post Office had become very defensive about expert evidence. Longuevort also suggests lawyers are prone to cognitive dependence and collective rationalization, a really interesting one, I think. Lacking expertise, computer systems would be a great example, they show excessive deference and dependence on others to interpret facts. So, at the inquiry, we heard repeatedly from lawyers that they defended their actions on the basis of their client's confidence or belief that Horizon was robust. Confidence and belief, not evidence. Lawyers are not just dependent on information from others, however, they manage it and they polish it. At the Post Office, cases went wrong sometimes and they were settled and buried under non-disclosure agreements. Central management of core knowledge about Horizon failures on cases was absent. Bad news disappeared. Witness statements were drafted in ways stronger than witness statements intended or were comfortable with. Even when not sinister, organisation culture and the tournament of influence can promote such cognitive dependency over professional independence. But lawyerly zeal can make it worse. Always dependent on partial information, we naturally burnish pro-client facts and arguments when we're preparing their cases. In developing a narrative, something arguable but probably false can take on the appearance of truth. Cognitive dissonance means we interpret new information consistent with past or preferred choices. It may have magnified polishing. Take remote access as an example. Remote access is crucial to the Post Office story. It meant Fujitsu engineers could change sub-postmasters' accounts remotely without the sub-postmaster knowing that it had been done, and that meant the system was insecure. It also meant it was a likely cause of accounting errors, and that the Post Office probably couldn't prosecute cases because of that insecurity. Now, the Post Office went from saying remote access was not possible, as we see here, to saying it was possible, but only with sub-postmaster consent, to then saying it was possible without consent, but controlled, to being possible but uncontrolled, but unimportant. Scout's honour. What then would a different approach be? Sensible advice as to the law and conduct, the neutral handling of facts and law. What does that really require? It requires facts and law to be marshalled, interpreted and presented as objectively, as unslantedly as possible. Uncertainties as to the facts or how to apply the law should be handled objectively, with clarity and openness about the risks and uncertainties. Only then can decisions about risk be taken on a fully informed basis with the best information available on those risks and in ways that most closely reflect what legality requires of the organisation. We've already seen how grease and zeal can distort facts consciously and unconsciously. When it happens, decisions about risk are taken on an inaccurate, slanted calculus, slanted towards the interests of the people supplying evidence and or taking decisions. This slanting of the calculus and questions about its legitimacy are important. There are two questions really. One is a question of process, how to ensure facts and legal interpretation are as objective as possible. Stepping out of cognitive dependency to deal with this takes real effort, skill, and a focus on proper evidence and not belief. And the second question is a question of substance. How risky does a legal decision have to be before an organisation should not take it? Let me move on to that second question with an example. The Attorney General's guidance on legal risk from 2022. It's actually earlier than that. This is the latest version. It was introduced by the last government to make government lawyers behave, as we're told by one government minister apparently, more like high-end commercial lawyers. It sought to strengthen the risk appetite of the government legal department. The guidance requires government lawyers to advise that there is a sufficient legal basis to proceed with a controversial policy unless there is no respectable legal argument that can be put forward to the court in favour of the action to be taken. So broadly, unless there is no respectable legal argument, government lawyers have to advise that there is a sufficient legal basis to proceed. Even a case with a more than 70% chance of being successfully challenged has significant basis to proceed. So cases very likely to be unlawful have sufficient legal basis. It gets a little worse. A lawyer inclined to say there is no respectable argument, to resist if you like, has to refer the matter to their line manager before they advise. If their manager disagrees, the advice will be revised to say there is sufficient basis. Now, advice should explain legal risks accurately and clearly and can suggest mitigations, but I think such guidance interferes with the independence of the lawyers involved. It encourages pressure to lean towards yes and to say that something probably unlawful is sufficiently legal. That has significant potential to mislead. The risk that such a policy will be abused by overweening ministers are, I think, obvious. The genius that says X is likely, even highly likely, to be unlawful, but can be represented as having sufficient legal basis, is that it allows the lawyers to give a superficial claim to legality and the ministers to say, well, the lawyers said we can do X. It designs in a mutual irresponsibility. Now, interestingly, the new Attorney General has announced plans to change this as part of improving the culture of rule of law in government, so we can expect improvement. We have to wait and see what it is. Let me move on to my next point, nuance and mutual irresponsibility. Dysfunctional systems are full of these kinds of responsibility gaps, policies and processes that distance decision makers from responsibility. Some gaps are designed, others are accidental. When it became clear in 2020 that Paula Venel's claim that there was no evidence to suggest convictions were unsafe was indefensible, she simply blamed the lawyers, adding she could not reveal the advice she had been given because of legal professional privilege. Lawyers in response have tried to say they simply advised in difficult circumstances and the client decided. Mutual irresponsibility. One example is the infamous application to recuse the judge in the Bates trial for bias, Mr. Justice Peter Fraser, as he then was. Lords Grabbanner and Neuberger advised that the Post Office had good prospects of success, and Lord Grabbanner in particular told them not just that they could or should, but that they had a duty to apply to recuse, a duty. In oral evidence, he said he did not mean a legal duty, but we don't know what kind of duty he did mean. His evidence boiled down to him saying he was obliged to advise the client how to win the case, and recusal was the only way. Putting to one side whether that is right or not, him telling the client they had a duty to recuse enables them to say, as they did, that in effect they had little or no choice. What choice did we have? These two leading lawyers were telling us we had to recuse. Let's look a little closer at other ways in which zeal, organisational dispositions and mutual irresponsibilities can give rise to problems. Now here I want to show how those drivers create repeating patterns, the irresponsible orthodoxies that I've talked about. In the post office scandal, these orthodoxies provided the post office justification for decisions, protected them from risk, and shielded them from scrutiny. The first orthodoxy is a world shaped by arguments more than evidence. Now, contracts are supposed to define rights, but when misused, they do more. They can mislead. They can drive abuse. The drafting of the post office contract with sub-postmasters is a case in point. It helped shape an abusive relationship. Its unreasonable terms held great sway through the business. Almost everyone behaved as if the contract required shortfalls to be repaid in all circumstances, regardless of fault. And it was even later redrafted even more unfairly to try to make liability explicitly no fault. The judge's decision in Lee Castleton's case in 2006 bolstered this unfair approach. He treated sub-postmasters as agents who had prima facie agreed debts when signing weekly accounts. This gave the High Court seal of approval to Horizon's legal defence. Post Office didn't have to worry about Horizon evidence anymore, but so sub-postmasters did. In Mr. Castleton's case, Lee had regularly disputed the £32,000 of shortfalls he was asked to pay in dozens and dozens of helpline telephone calls. Even so, the argument was run, the case was run, on an argument that Mr. Castleton had agreed shortfalls because he signed the accounts each week. Legally, this is a reasonable argument, a nice little legal point, as Jason Beer called it in the context of the inquiry, but it also depended on an illusion. Mr. Castleton only signed such accounts because his contract required him to. He had to accept the accounts each week or cease trading. Their truth was challenged, and was challenged in court in the only way possible, through ringing the helpline and hoping something happened. Draconian termination clauses gave the Post Office further leverage in such situations. It was legal totalitarianism. It sounds extreme, but I think it's a fair description. You have agreed shortfalls. You owe us the money. You can't prove otherwise. We will fire you or sue you or prosecute you or terminate your contract if you don't pay up. Post Office investigators, to make matters worse, were paid bonuses to maximise recovery under this Machiavellian deal. And that unfair contract survived for 20 years. It took the extraordinary Bates case to undermine it. There are many other occasions when arguments were deployed by Post Office lawyers at some remove from the facts. When Mr. Justice Fraser famously said the Bates case was a flat earth case, he meant witness statements were based on what the Post Office wanted to be true, not what was true. The implication seems to be evidence handling was either negligent or improper. Evidence about remote access was filtered through a lens of what they wanted to say, and so on. My second orthodoxy, zeal, not independence, dominating decision-making. Disclosure is a great example of this. Disclosure of relevant evidence was repeatedly refused by Post Office lawyers. When the inquiry has considered this, file notes and emails suggest their lawyers sought a rationale for not disclosing rather than objectively applying the relevant disclosure tests. Some decisions were impossible to defend in the inquiry, and they were conceded as flawed under cross-examination, but usually only with hindsight. One email from Bond Dickinson, drafted by two of their solicitors whilst working on the Bates case, suggested suppressing evidence and seeking to advance arguments that appear legitimate until the pressure to provide the documents becomes too great. So we'll suppress under the appearance of legitimacy. One of the lawyers responsible for that now says there were in fact legitimate grounds for resisting disclosure, and he knew that at the time. They just were not mentioned in the email. Now this leaves me with a question. Did they think they were suppressing evidence at the time or not? Or were they just making a show of suppressing evidence to impress the clients? One is worse than the other, but they're still both not great. The resistance of disclosure, repeated, spread across time, across different lawyers, different cases, different teams, suggests a problem that is deep-seated, endemic even. The lawyers were incapable of ensuring proper disclosure. Zeal turned disclosure rights on their heads. Sub-postmasters' rights became Post Office rights to resist, including, as we will see in the next orthodoxy, the exploitation of privilege. In 2011, in response to 4 sub-postmasters' claims, a lawyer in the Royal Mail Group, Royal Mail owned the Post Office then, issued a litigation hold to Post Office staff. It's a fairly common step. Worries were growing about a group action. A litigation hold is a warning to keep all relevant documents safe. This one also discussed document creation. Again, not uncommonly. It emphasised controlling the creation of documents that might be potentially damaging to Post Office's defence, because these documents might be disclosable. Everyone was urged to think very carefully before writing down anything critical of our own processes or systems. If there was a need to write something down, staff were told how to try and attract privilege to it, how to shield it from disclosure. One tactic was to encourage staff to write down adverse evidence in a way that its dominant purpose can be said to be evidence gathering for use in litigation. Can be said to be. Litigation holds and maximising legal privilege are orthodox. They are seen as protecting the rights of the client to potentially privileged documents. But as we can sort of get a sense of here, they can also encourage potentially synthetic claims to legal privilege. Here, not only is harmful evidence shielded, the lawyers discourage it from being created in the first place. They send a particular signal, if you like, into the business. If such evidence is created, they encourage the synthesizing of arguments for resisting disclosure. Whether this is an abuse or not probably depends on whether we think the business and the lawyers were acting in good faith and how the litigation hold was actually managed. As we have seen, disclosure was routinely resisted, often enough improperly to cast doubt on that good faith. And good faith brings me to orthodoxy 4, sophisticated evidence management. The aversion to creating or dealing with adverse evidence can take other forms. Richard Morgan, a barrister, now King's Counsel, who led Post Office's case against Lee Castleton when it got to court, described his general approach as, "I'm trying to find out what's going on without being so crude as to say, give me full and frank disclosure. I want to know, are there any unexploded landmines that I'm going to step on if I go down a particular course? Is there anything that's going to come out that I should know about now?" Generally, with a sophisticated firm of solicitors, they know that that's what you're asking them when you say what's out there. Sophistication seems important here, but it is left opaque. Full and frank disclosure to him, we can see, him who is leading the case before the court, it's seen as crude. There appears to be merit in him not being encumbered with specific adverse knowledge, if possible, unless he's going to, if you like, step on it. We get another sense of these tactical instincts at a meeting with senior post office lawyers 5 or 6 years after Mr. Castleton's case. Here, Mr. Morgan was asked to advise the post office should they have an independent investigation into Horizon. Fresh cases are looming. The note of the meeting, and probably Mr. Morgan's view, but perhaps the collective view of the group, was no. Whatever the findings of the expert report, the minute says, it will not resolve the problem. Post office will be damned if they do and damned if they don't. Either the report will be seen as a whitewash, or it will open the floodgates to damages claims by sub-postmasters who were imprisoned for false accounting and all civil cases they are currently sitting on. Notice the focus is on making cases go away for the post office rather than the potential miscarriage of justice. Those cases clearly, we can see it in the note, include possible wrongful prosecution claims, but Mr. Morgan tries to distance himself from this as beyond his expertise. The desire is to respond tactically rather than face up to the potential injustice. It's a pretty explicit moment of turning away. A rock is not lifted. Now, an absence of rock lifting, as we can see from these examples, was a feature, not a bug, of this scandal. A central example surrounds Gareth Jenkins. He was a Fujitsu software engineer who gave evidence in various criminal trials, including at Seema Misra's trial. The post office's lawyers had not handled him properly. They, for instance, sought to harden his evidence in their client's favour and did not advise him adequately on his obligations to the court, whilst nonetheless holding him out as an independent expert. When problems with his evidence became apparent, Simon Clark, a barrister working for Post Office's criminal law firm, Cartwright King, reviewed Mr. Jenkins' witness statements and said Dr. Jenkins' credibility as an expert witness is fatally undermined. That was because Mr. Jenkins had failed to disclose in evidence Horizon problems of which he was aware when he gave evidence in, for instance, Seema Misra's trial. Now, interestingly, Simon Clark does not probe this with Mr. Jenkins to find out what might have gone wrong. He went from thinking When he first looked at the cases, he had to find out what had gone wrong, and he needed, in his words, a face-to-face conference with Gareth Jenkins to simply reviewing Jenkins' statements and saying in his advice that why Dr. Jenkins had failed to comply with this duty are beyond the scope of this review. It was taken out of scope. Clark says his failure to lift this rock is down to him wanting to look forward, not back. That's what he says to the inquiry. He says he did not know his firm might have been involved in the original problems with Jenkins's evidence when it was used. If he'd known, it would have been a conflict of interest, and he'd have had a reason not to lift the rock. Brian Altman, King's counsel, appointed to review Cartwright King's work, agreed Mr. Jenkins was clearly tainted. Mr. Altman also started off his work saying he would have to consider carefully seeing Mr. Jenkins, but he too decided against it. Altman explained his change of mind on the basis that he was only reviewing Cartwright King and not investigating. His review didn't pick up on the problem with not speaking to Mr. Jenkins. Counsel to the inquiry, Jason Beer, suggests not speaking to Jenkins meant the Jenkins issue, in his words, remained shelved, never to be returned to. Asked, weren't you not loading the dice by excising him? Altman replies, I don't see it that way. Another example of not lifting the rock occurs when Simon Clark warns Post Office General Counsel, Susan Crichton at that time, that minutes of disclosure meetings may have been shredded. His advice warns that, if repeated, this would amount to criminal and professional misconduct for anyone involved. His advice was not responded to for 2 weeks. It then prompts a rather wishy-washy response, saying, in essence, I paraphrase, if this has happened, it would be bad, and contrary to our policy. It doesn't deal with whether or not it really happened. In spite of this, and a threat to blame them for the problem, the Cartwright King lawyers say they were reassured the issue had been addressed. They cannot remember how, and there's no evidence that the shredding, an allegation of criminal misconduct in a review of criminal prosecutions, no less, was properly investigated. From this point forward, whenever it is mentioned, the shredding episode is referred to not as shredding, but as cultural issues that have been addressed. It's something in the past and it's just a cultural issue. The rock was replaced and covered in the moss of my next orthodoxy. Speak bad news softly, good news brightly. Calling shredding cultural issues is but one example of bad news being spoken softly. And we know that when Susan Crichton reported in writing to the board in 2013 on the emerging catastrophes of Gareth Jenkins' evidence and Second Sight's work, she failed to convey their full significance. To be fair to her, she was excluded from the board meeting where she was due to explain it by the chairman, and humiliated, she's managed out or leaves the business shortly afterwards. As the bearer of bad news, she muted it, and she still paid the price of a messenger. This orthodoxy, speaking bad news softly, good news brightly, primarily relates to investigations or advice organised by the client or provided by the lawyer in ways designed to maximise helpfulness to the client, the slanted signal, if you like. Being helpful being a phrase here loaded with meaning. We've started to see this helpfulness in the political domain. David Pannick's advice on the Boris Johnson Privilege Committee inquiry might be just such an example. It was criticised for its approach and content, but the advice itself may be a creature of its instructions. Linklaters provided advice helpful to Lehman Brothers off-balance sheet accounting. There was nothing wrong with the advice, but it was misused in ways arguably foreseeable by the lawyers. This raises an interesting question as to what such foreseeability requires of lawyers, if anything. Lord Grabbanner's independent review of alleged misconduct in the Bank of England tested alleged misconduct against criminal standards when professional standards would perhaps have been more apt and more likely to lead to the bank being criticised. One test, if you like, was more helpful to the bank than the other. Independent investigations into corporate misconduct like this are routinely derided as being whitewashes subject to cherry picking. The Post Office contains a series of reviews that I would argue had significant problems in remit and execution, Cartwright King's review of their own criminal prosecutions, and Brian Altman's review of their review being cases in point. To give one example, they failed to deal appropriately with the fundamental conflict of the firm marking its own homework. These reviews were then filtered through the Post Office's PR lens to say convictions were not unsafe, or Horizon was fundamentally sound, or it was without systemic problem, good news being spoken brightly. A third review, the Swift review, raised many of the problems the inquiry is now investigating, but it was kept from the Post Office board after probably erroneous advice from the General Counsel, Jane McLeod, and it was also summarised in a rose-tinted way for the government minister. It was also reported in a way, I think, misleading to Parliament. Let me move on then to legality illusions. This organisation, execution and communication of legal work shows us the purposes of lawyers from the perspective of clients like the Post Office. It was to provide professional backing for their own particular partial version of the truth. Organisations who are used to representing messiness in positive and simplified terms, sometimes for good reason, but when willing to encourage and accept such illusions where they are useful and can be defended, lead to this kind of behaviour. To capture this, I have begun to develop the idea of legality illusions. In general terms, I see legality illusions as fostered illusions of legality or justness by which lawyers and their clients abuse power and avoid accountability. More specifically, I define legality illusions as misleadingly or unlawfully implying or asserting actions, decisions, and assessments of facts are just or legal or within the law or true, fair representations of facts, when they are likely or highly likely to be unlawful or illegal or untrue. To summarise it, to boil it down a bit, misleadingly asserting that what they have done is just, when the likelihood is it is not. Now, I don't want to try your patience with a full defence of this idea or definition, but it goes beyond existing theories of lawyering like creative compliance. Creative compliance is defined as artful compliance with law in form but not spirit. What we see in legality illusions is, I think, worse than that. A legality illusion is a probably deliberate or reckless attempt to behave unlawfully or mislead others. Take Standard Chartered Bank's wire stripping of transaction identifiers off Iranian money transfers. So they wanted to get Iranian money cleared into US dollars quickly. The clients wanted it done really quickly. The transfers seem to have included handling money. And the banks did this by disguising transactions, by removing those Iranian identifiers to avoid US sanctions control. Lawyers in London were central to this, an orchestrated strategy to manage a breach of US law. Advised it was unlawful by outside lawyers, the lawyers nonetheless told their risk committee it was reasonable. By disguising the transactions and not telling their US sister company, they thought they could enforcement proof it. The illusion of reasonableness and enforcement proofing was pricked by the US regulators. They said it was a fraud and disgorged a massive fine in settlement. Many other banks, it turns out, were doing similar and were later fined in even greater terms. Second example, Barclays. To stave off government intervention during the financial crisis, an injection of Qatari funds was papered by Barclays lawyers to look like a consultancy agreement. It was an illusion that was used to mislead various people externally and possibly internally about the deal. Example 3. UBS commissioned a lawyer to review an alleged rape investigation. A judge said lawyers and the bank had cherry-picked conclusions that were favourable to and exonerated the respondent. The illusions that they had handled the case properly then took something of a beating. In the first two cases at least, a strongly arguable case can be made that the lawyers knew that what they were doing was illusory. This idea of legality illusions is derived from academic Dean Curran's risk illusions work, which itself draws on the great Ulrich Beck's idea of organised responsibility. Their work suggests irresponsibility and illusion are products of the system, made of but bigger than the individuals that populate the system. Individuals may even sometimes be powerless to prevent problems manifesting. If they are right, zeal might mean facts and arguments are inevitably slanted because that's what the system is designed to do, the system of lawyering. In the post office scandal, many hands certainly contributed to the ways in which contracts constructed an illusion of fault, prosecutions an illusion of crime, and the reviews and the reviews of reviews illusions of propriety, safety and soundness. Strategies of excess in contract management, in litigation, and the handling of press and politicians cemented these illusions. At almost all stages along the chain, though, the post office managers and lawyers would, I think, argue that they were engaged in the good faith management of uncertainty. They may have admitted with hindsight they got decision X, Y, or Z wrong. They may not have disclosed facts A, B, and C, and they sometimes used non-disclosure agreements or slaps or overclaimed, or worse, professional privilege. But what they were really doing is simply what the rule of law required of them, interpreting the facts and law to their client's advantage, and that, they might say, is their right. To say simply I am defending my client's rights, as I am obliged to on the facts as they tell me, is an abstraction, a shallow script which largely disintegrates when the lawyers become tightly woven into the client's actions, as in-house and private practice lawyers did in this case. They almost kind of became the client. To put it another way, considering irresponsible orthodoxies in context shows how vital it is that the rule of law is professionally and responsibly administered. Understanding the purpose of lawyering in these circumstances is crucial. It's why the casual admission of evidence suppression may be so telling. Assessing the quality of professional judgments can only be done in context against the purpose. Nonetheless, legality illusions, like risk illusions, are a product of the system's logic and practices. They are made of individual acts, often smaller failures in themselves than the problems they lead to. Taking a nice little legal point to defeat Lee Castleton, shaving a sentence in an expert's report, not lifting a rock that the client seems to be sitting on, redacting Gareth Jenkins' name from a key document. None of these explain the scandal on their own, and it's easy for the lawyers involved to try and diminish their responsibility as a result, because none of them on their own are equal to the scale of the disaster. And not all, of course, are actionable misconduct. But together they have created something truly awful, part accident, part misconduct, but part also a kind of conspiracy to pervert the course of justice, either conscious or semi-conscious or kind of organised by the system's way of thinking. My argument is that what joins them together are professional frailties, irresponsible orthodoxies, and amongst some lawyers and clients, an appetite for legality and illusions. In conclusion then, what should we do about these problems? Honest representation of facts on the ground, objective, balanced legal advice don't seem like much to ask, and yet they are more difficult to achieve than they look. I believe we must challenge the orthodoxies of zealous ideology, ensure practitioners think more contextually and with a keener eye on the consequences of their actions. We also need to find ways of ensuring accountability for the risks they and their clients take. It is absolutely not all about lawyers. This requires thinking about ethical lawyering as an institutional and behavioural practice. Rules and enforcement are important, but so too are defining the structures and behaviours that active independence and objectivity require. Thinking about the purpose of lawyering in any situation helps us think about what is really influencing decisions. Understanding ethics and its social and psychological contexts suggests we should spend less time on political philosophy and more on a basic and really practical question. What do we need to do to promote more rigorous, honest integrity and independence of judgment? The professional codes already demand these, but are being undermined in practice by culturally embedded scripts laced with zeal and irresponsible orthodoxies. We can see this culture in what is bought and sold in the market for legal services. Let me illustrate with two examples. The chambers of one of the leading barristers involved in the post office scandal marketed his services until recently like this. as a steamroller that crushes anything getting in his way. And another, again until recently, being sold like this, as someone who can turn a pile of refuse into something that looks great. Steamrollers, or a Midas with the refuse, with the brown stuff, are being sold at the apex of the bar. If I am steamrollering my opponents or rendering refuse golden, we see how deeply embedded ideas of aggression and illusion are. What the real purpose of fearlessness and zeal is, what clients think and are encouraged to believe the orthodoxies work towards. It is mercenary logic dressed up in professional finery. Integrity, independence and respect for the rule of law are threatened by these excesses of zeal, by irresponsible orthodoxies, and by a taste for legality illusions. In the post office case, it looks like lawyers were leading the line on their creation. We should take profoundly seriously the problems this creates. It is a larger problem than one enormous scandal. Sir Brian Langstaff's report on the infected blood scandal defined a cover-up as deliberate concealment, a lack of candour, the retelling of half-truths, and the massaging of risks. His list looks like my list of orthodoxies. Cover-ups are not always, but of course are not uncommonly, legality illusions. To restrain them, we need to punish the failures that amount to misconduct. All of them. But what else? We also need to think more fundamentally about the systems, rules, and approaches that lead to better ethics that answer this question. And that's what next week's lecture is about. Thank you for listening.